How to answer the petition and use general defenses when you're sued for debt. Brought to you by Kenneth Chabert at yourlegallagup.com. Your advantage if you're being sued by debt collectors. Answering a petition is actually extremely simple. No one should ever lose a case because of not answering. But in debt law cases, 80% of them do. You won't be a part of that 80% though. Take a look at the petition. A sample of a petition actually received by one of my clients is on the following page. Don't be alarmed by the amount of print on this page. We will take each allegation in turn. I'm just going to let you take a look at the petition here. This was the entire petition for a whole lawsuit. And I want you to see that it's really a very sloppy document. And the lawyers who do these things don't do them very carefully. In fact, they're usually done by some sort of software, I'm sure. So whether a lawyer ever saw this or not before signing it, I doubt. For purposes of this video, I will address only this simple petition. You may have a more complicated one, it may be a little better done, but you'll just do the same thing for all the counts of your petition, looking at them each paragraph at a time. We're going to go through it now. Paragraph 1 is called the jurisdictional paragraph. The purpose of this paragraph, which doesn't necessarily have to be paragraph 1, is to establish the court's right and power to decide the case over you, the defendant. In other words, paragraph 1 must allege that the defendant lives within the jurisdiction or spends enough time within it for it to be fair for the court to exercise power over you. That's a constitutional requirement. Paragraph 1 in this case, where they say the defendant resides or can be found in city/county X of state Y, does not allege jurisdiction. Why? Because it does not identify whether it is alleging the facts about the city or county, which are two separate jurisdictions. It's ambiguous, and that it does not choose which one to allege. And of course the case is brought in a specific jurisdiction. In this case it was the county. And so this paragraph doesn't clearly allege that the person spends any time in the county, just the city or county, and that's not good enough. You could therefore, in your response to this petition, write either denied or objection, ambiguous in that it does not actually allege a single fact. If you object, you may want to file a motion to dismiss instead of actually filing an answer. I didn't usually do this, but I have suggested it for pro se defendants in another video as an early opportunity for you to fight and win. And it will show the plaintiff that you're serious about this, and it'll cost them money. So if you object, you may want to go to the motion to dismiss video and then come back here later after the debt collector has filed an amended petition. Let's just deny it here, though. Although if the facts are correct and properly stated, you might just admit it, like this. Paragraph 1, admit. So your answer now looks like this. Defendant John Smith's answer to petition comes now defendant and responds as follows to the complaint. Paragraph 1, deny, or admit, as the case may be. Paragraph 2 here suggests that you ask the debt collector to advance money. And we're going to come back to that when we talk about counterclaims, because in this petition, the debt collector did not identify itself as an assignee of, the credit card company. And we argued that this paragraph where they said you asked them for money was misleading and deceptive and in violation of the Fair Debt Collection Practices Act. If they get it right, though, and they allege that you asked the credit card company for money, they still didn't say when, where, or how much, or for what, or any of that, and so we would deny it. So I would typically deny such a paragraph. Paragraph 3, alleging that the charges are fair and reasonable, I would always deny, because credit card charges are never fair or reasonable, or if they're talking about the goods, let them prove it. Paragraph 4 of this case, I would deny. They attach a document, which is a generic cardholder agreement signed electronically by the CEO of Citibank, and they claim that it is the cardholder agreement, which would have some relevance for you. That, I think, definitely remains to be seen. Paragraph 5, that after all credits have been applied, there remains a principal balance of, X amount of dollars. I would definitely deny, unless you know for an actual fact that every charge on the card is valid, and you also assent to the ridiculous amount of interest and late fees that they've added, and unless you also remember with certainty that you never paid any of it. And since none of my clients ever went along with any of that, we always denied it. Number 6, that after that a demand was made and you refused to pay. We would typically deny this, although, it didn't matter because in most states the law treats this as accomplished by the filing of a lawsuit, so that is the demand, and denying it is just kind of a technicality, but you could still deny it and make them argue it. So we come to what's called the wherefore clause, where they ask for specific amounts of money. Since we are denying all the factual allegations, we're also going to deny owing them any money in the wherefore clause. It looks like this. Wherefore, defendant prays for judgment that he owes plaintiff nothing, and for his costs and expenses incurred in defending this matter. In other words, you're asking for, a declaration by the court that you don't owe anything to the debt collector, and for the court to award you the costs and expenses that you incurred in defending the lawsuit. So that's it. We have denied the facts of each allegation, and since this is the debt collector's case, it will have to prove each of them now that we have disputed them. And that would be true of any paragraph that you dispute. Obviously, if you don't dispute a paragraph, they don't have to prove it. So you'll have to bear that in mind. And they've got to prove that you owe the money. So that's it for answering the petition. If you want help in creating affirmative defenses or counterclaims, be sure to check out my videos on those topics, which are reserved for customers. You may not consider this video or anything I say in this or any video as legal advice. I cannot give you legal advice, but I do know the legal process and debt law very well, so use what I say as a source of information and apply your own judgment to your case. To get more help on fighting debt collectors and their lawsuits, go to yourlegallegup.com, get my litigation manual and forms, and defend yourself from the debt collectors.